Conway here, and we're going to change the course for your financial future. So what do we want to talk about today? Today's topic is asset protection. If you own real estate, or even if you don't own real estate, but you plan to, and you're married, what you want to do is put the title to your real estate in a form of property known as tenants by the entireties. Tenants by the entireties. That is an odd phrase, and what it meant historically, like 1,000 years ago in England, was that a husband and wife were one. And so a husband and wife were one, and therefore their real estate had to be one. And tenants by the entireties is a form of real estate where both the husband and the wife have to agree to sell it, and they both have to sign the deed. And the creditors of a husband and wife, only the joint creditors, where they both signed, can kind of attack or take T by E property. Tenants by the entireties is known in the trade or industry, in the title industry, as T by E. Tenants by the entireties for short is T by E. So you want your real estate to be titled T by E. And that's why many times when we have real estate, we are always trying to obtain a title search before we file your bankruptcy. We want to make sure that the title to your bankruptcy is tenants by the entireties with common law right of survivorship. That's the magic phrase, right? But there are other nuances. There's also joint tenants with common law right of survivorship at the time that you were married. But that's the principal means of protecting assets in the Commonwealth of Virginia. Sometimes people say, I'll put it in a trust or something like that. That's not really a means of asset protection. Tenants by the entireties is what you want. And sometimes clients will come to me, and this happened yesterday, which is why I'm bringing this up. He says, well, my neighbor was able to file for bankruptcy, and he filed a Chapter 7, and he got all of his debts discharged within 110 days of filing. And I said, yes, you're right, but every case is different. And in your case, when you got married, you put the title all in your name only instead of in your name and your spouse's name, and therefore you can't file for a Chapter 7 bankruptcy, because if you did, the trustee would sell your house. So every case is different, and sometimes clients treat bankruptcies as a commodity, and you shouldn't do that, because maybe a lot of cases are run-of-the-mill cases, but then a couple of cases a month or not, and you could really lose your assets and lose a lot of things that you expected to maintain. The other issue that comes up with T by E property, once I kind of have this break this bad news to the client, is they'll say to me, well, I'll just retitle it now. And you can't do that. That would be called a fraudulent conveyance. Queen Elizabeth I created a statute against fraudulent conveyances, and I guess they had a lot of crookedness way back when, and she created that statute, and it's been in American law, American jurisprudence ever since. And so once you owe a debt, if you convey real estate or personal property or cars or anything, once the debt is owed, the trustee can set that aside, and it's called a fraudulent conveyance. And in fact, if you have a fraudulent conveyance within a year of your bankruptcy filing, that's a grounds to not allow you to get a discharge. So if you come to me and you have this issue, it's very hard, if the property is not titled correctly, it's very hard to correct that after the fact. So if you have this video, even if you don't own real estate now, I'm telling you for the future, put the real estate in the correct title form, tenants by the entireties with common law right of survivorship. Okay, change the course for your financial future. Thanks, and have a great day. Bye-bye.